Welcome to Trial Tips from Practice Masters, sponsored by the ABA Career Center. Moderating the program today is Kathy Morris. Kathy is founder of Under Advisement Limited and former director of career counseling and placement for Northwestern University School of Law, former director of the ABA Career Resource Center and the Center for Continuing Legal Education. She has decades of experience with guiding law students, lawyers, and law firms focusing on attorney training and professional development. Kathy, you may proceed with the program.
Thanks, Bonnie. Welcome all to the kickoff program of our 2015 ABA Career Advice Series, as you saw and heard from Bonnie, sponsored by the ABA Career Center. We're going to focus today on tips from trial practice masters, and we know that not every lawyer, in fact few lawyers, are on trial all the time. With the advent of binding arbitration and more mediation and with the cost-benefit advantages of settling cases, it really may be only a few times a year that litigators gear up, become trial lawyers, kind of give it your all. But to those who do go to trial more often, and to those who every once in a while find them to be trial lawyers, we invited two leading expert trial lawyers, two people who actually, and this is true, love trying cases, to give you their thoughts and advice on how to do it, who's best suited for it, and to answer some of the questions you may have. So let me quickly introduce them to you today. We're covering both coasts. Jan Nielsen Little is an award-winning partner at Keker Van Nest. That's a premier litigation boutique located in San Francisco, which is where Jan is today. And she informed me, as I'm sitting in Chicago, that she didn't wear a coat to work, so I'm a little bit upset with her to start anyhow. But Keker has about 85 lawyers or so, and for more than 25 years, Jan has handled those high-stakes, what we used to call, when I was a federal defender, heater cases. She does white-collar criminal trials and complex controversies for companies and senior executives. And she received her undergrad degree from Berkeley and her JD from Yale. Also, Andrew Smiley on the other coast in New York City is the lead trial attorney for Smiley and Smiley, a small firm in New York City that his father actually started and that Andrew now proudly manages. He very interestingly also regularly appears on television, providing commentary, in the high-profile personal injury, med mal, wrongful death cases. Something I think you'll find interesting as well. An officer in the local and the state trial lawyers associations. Andrew graduated with honors from Tulane and got his JD from Brooklyn Law School, where he was very involved with trial practice even at that stage. Now, as you know, if you've been part of our series, we go over top issues and then have a conversational give and take with with today Jan and Andrew. They have some tips for you. We take your questions. There's an agree-disagree moment where I throw out a concept and they either agree or disagree and say why. We may be able to take more questions throughout and end up with some takeaways and some ABA resources for you as we end the program on time at the top of the hour. So I wanted to maybe start with this question, and let me throw it out to Andrew first. And whatever your answer, no, we're going to dive down on the subject. So just sort of a top tip for trial lawyers. Andrew.
Hi.
Hi.
Hello, everybody. Greetings from New York City.
And your top tip, Andrew?
My top tip is to be prepared. That is my living mantra, is that preparation is the number one key for most things in life, and certainly in any area of trial practice and trial work. You must be prepared, and the higher level of preparation you come to court with, the more successful you will be.
Okay. I think sometimes people think, oh, people go to trial a lot. They don't need to. They get the hang. They don't prepare as much. That isn't true. You're going to hear that these folks prepare just as much as they possibly can, as senior as they are. That's so interesting. And Jan, do you agree with that? Do you have a tip for the audience?
I totally agree with Andrew. There's just no substitute for rigorous preparation. But on the other hand, kind of a related tip is something I always tell young lawyers. One thing you can always expect in trial is the unexpected. Surprises are inevitable at trial no matter how well prepared you are. So in addition to being prepared, you also have to be nimble, which is to say you have to expect that you're going to have to think on your feet.
Okay, all right, that's interesting too. But let me combine those two top tips. So let me ask Andrew, can a trial lawyer prepare for the unexpected?
Absolutely, and that's what a good trial lawyer, a well-prepared trial lawyer does. For example, you may expect that you're preparing your cross-examination of a witness, and you may expect that the witness is going to, provide the answers that you read about in that witness's pretrial deposition. It may be unexpected for that witness to come up with something completely different from what they testified to prior to trial in a transcript that you have. But you need to prepare for that they may do that, and be prepared to impeach them with their prior inconsistent statement, and so that you can have as much of an impact at trial if that does happen. So while it may be unexpected, you are preparing for certain unexpected things to happen at trial so that you can take advantage of it when it does happen.
And I guess experience can breed confidence, and that helps you kind of be anticipating these twists and turns and unexpected possibilities, what you might object to, etc. But Jan, what if people don't have the years of experience, that you and Andrew do? How do they sort of focus on what to do if something comes up that really is unexpected for them?
Well, again, hopefully you've prepared enough at whatever level of experience you have. You've prepared enough to give yourself the confidence that you'll be able to handle anything. But if all else fails and some total zinger out of the blue comes, there are sort of life rafts you can go to. You can ask the judge for a moment to consult with a colleague. You can, if need be, ask for a short break to consult with your client or with a colleague. It's not ideal, but it's better than going forward and making mistakes. If you really are caught at a loss, there are opportunities where you can ask for either a break to consult with counsel or a break to even go out and make a phone call.
Okay.
And the other thing is, again, just preparation is really the key. And each case that you handle, you just have to approach with the level of particular preparation that case needs. Some need more than others, and you just need to be mindful of that.
Well, it might help the audience, Jan, if you could illustrate with an example, maybe how you've differentiated your preparation in a particular situation or case.
Sure. I tried a case a few years ago where the judge was incredibly hostile. He was known to be hostile. It was a criminal case, and he was known to be hostile to criminal defendants, and he had demonstrated that hostility in our pretrial work. And so as I prepared my examinations in this case, I did something that I don't normally do, which is for each question I was going to ask, I kind of mapped out what are the possible objections that could be made, what are the possible interruptions the judge could do, and trying to clamp me down, and what are going to be my responses. If the judge says this, I'll say that. If the prosecutor says that, I'll say this. So that I had all my escape routes kind of mapped out well in advance, which helped me as I started to perform my direct cross-examinations. I felt, I had all the tools right there ready.
And you had everything actually written out, which I don't
normally do that. I don't normally do that because it's kind of stifling. But in this case, I knew that I was walking into a landmine field, and I just wanted to have everything lined up. And it was helpful. It was very helpful.
I think that would be comforting in some occasions. But Andrew, what about you? Do you have a sort of a tale of sort of how you went about something for a particular case?
I do. It's every once in a while. Sometimes trials can be fun because something explosive happens or something interesting or surprising that you can take advantage of, and that ends up working out to your benefit. And again, it can happen by way of preparation. You can fall into it. And I recall a time I was handling a case, and I specialize in personal injury law, and this case involved my client was intoxicated taking a subway home from being out in the city in New York City. And He got down to the subway platform waiting for the train, and he passed out and fell onto the subway tracks. And the train came along and ran him over, and he lost his leg as a result of it. And we were brought into the case, and our goal was to prove that the train operator could have stopped in time, and that even though our client was intoxicated, the train still shouldn't have run over him. You don't get a free pass because the person on the tracks is intoxicated, as opposed to maybe they fell because they were pushed or had a seizure. So the defense, it was their time for the defense case, and they called an expert toxicologist. And we knew that it wouldn't look good that our client was intoxicated, but the facts were what they were. So all from jury selection on, we acknowledged it and said, you'll learn that our client was intoxicated, so much so that he passed out on the tracks. So I was surprised that the defense in the first place even felt the need to call a toxicologist to the stand to basically testify and give testimony as to something that wasn't in dispute. But they did, and I got his CV and his resume, and the night before and I didn't expect to frankly spend a lot of time questioning him, other than a few questions saying that there's no dispute our client was drunk, and thank you for flying in from Florida to New York to tell everybody that. But the night before his cross-examination, I do what I always do before questioning witnesses, is I Googled them. And I went through Google and I looked this toxicologist up, and on like the second or third page in, lo and behold, I struck gold, and I found a document that showed that this toxicologist used to run a lab up here in New York and got into trouble for doing bad things with his lab and got investigated by the state attorney general, and as a result of it, took a plea type agreement or worked out some deal and agreed not to practice toxicology in the state of New York for 3 years and signed off on it. And thanks to Google, the document was right online. I clicked on the PDF, which printed out the document with this toxicologist's signature on it. And I said, now that's interesting. This guy was suspended at the time of our accident to practice in New York, and he still is suspended, yet he's coming in as an expert. So I couldn't wait to bring that out. I said, all right, it's something I can play with if need be. So during the cross-examination, he testified as I expected on direct. Yes, my client was drunk. And I got up there, and I sort of laid the groundwork. I baited him into it, going through his credentials and made it seem and gave the impression that everything was fine. And then I sort of started off with, well, you had a little bit of a problem here in New York, didn't you, sir? Didn't you, doctor? And then you start seeing everyone's eyes light up. And then I start holding up this document, and I see his lawyer start to sweat. And then I bring it out as to what happened, and the lawyer jumps up for him, objection, and the judge says, what's this all about? And we come up to the bench, and the jurors all sit forward a little bit, and I show the document to the judge, and he flips through it. He says, all right, I'm going to allow it. So he let me really get into it and mark the document and really show that this guy did some bad things, and he basically got off the stand and walked off with his tail between his legs. And that was fun, because even though it was a surprise, in the courtroom it was sort of a planned element, and it was something I found the night before that I could use. So that made the experience a lot more fun than just a short witness that I didn't have too many questions for.
Mm-hmm. That's really kind of one of those rare Perry Mason moments, I guess. But fun, you mentioned the word fun, so I'm curious. So let me ask you in follow-up, Andrew, do you always find trials fun, and is that one of the gauges of a real trial lawyer?
I think so. I don't, trial work is stressful, very stressful, and sometimes I say, why do I do this? And I have a recollection one day that I was driving home from a day in court where I just had a really extremely effective cross-examination of a medical witness for the defense. And I was so pleased with how it went, and I really got my points across, and really, it went really, really well. And I was so pleased. It's almost like an adrenaline rush you get, and you're so thrilled with how everything comes out. It's like performing for anything and preparing, whether it's a sporting event or theater or anything else, and just delivering. Sort of, I say, like, picture a gymnast going off of any type of apparatus and sticking the landing. And so it's that thrill you get when you can finish up with a witness or a day in court where you really feel that you nailed it. You had prepared and you stuck the landing. And that part is fun. Conversely, if things don't go so well, it cannot be fun. But yes, if things go well and you're prepared and do it properly, there's certainly an element of excitement and adrenaline that I would call fun.
Jan, do you feel the same way?
I do. I mean, I always think trials, it reminds me of like a roller coaster ride. It's fun in that sense of it's terrifying. It could be sort of physically rattling, and as soon as you get off the roller coaster, you want to run around and get on again. It is fun, and it is that adrenaline rush, and it's that all-in feeling of just using your mind, your body, your voice, everything to try to convey your point and advocate for your client.
You know, speaking of theater, and there's lighting and there's staging in theater, but you know, courtrooms are courtrooms pretty much. But what about wardrobe? Andrew, can you talk about your choices of clothing and
Sure.
even choices for females, kind of when all eyes are upon you, so to speak?
Yeah, I take my time in thinking about what I'm going to wear and what I'm going to wear on certain days, and how I present it. First off, it's so important as a trial attorney that you dress nicely and neatly and professionally. One of my pet peeves is when I go to court and I see a lawyer show up in my case, or whether I'm observing it, but see someone in a court of law that has their shirts hanging out and their tie isn't tied up right, and things are hanging out of their clothes, and they just look slovenly and not put together. And I think that this just shows a lack of respect for the process. So I'm a big believer in being buttoned up. I don't even like to have pens in my hand to wave around or a hand in the pocket. When I get to court and I'm on trial, I take my wallet out of my suit jacket, I take my phone out, I take my change, my keys, I put everything into my trial briefcase next to me. I make sure I'm buttoned up and ready to go. And I think that is important because you're being judged, whether you like it or not, and your clients are being judged, and you reflect your reflection upon your clients. And if you present yourself as someone very well put together, I think that's going to carry for you as someone that maybe puts together their case properly. And if it's all part of the same package, it's important. So I'll dress nicely, always wear my nice suits, make sure I have my clothes cleaned before trial, dry cleaned. I'll wear maybe a brighter, nicer, vibrant tie on my opening and summation, or when I'm doing cross-examination. Those are times when the juror's eyes should be on you as the trial attorney. If I'm doing something like a direct examination where I want more of the focus to be on my witness and not on me, I might wear more muted tones, not as much of a flash. And as for, that's how I would dress in my suits. As far as, how a woman would dress, again, just very professional. You don't want to come in wearing something that might be appropriate if you're going out to dress up for a dinner party in the evening. Nothing too sexy, so to speak. You want to be very subdued and professional. Not a lot of jewelry. I always tell clients or colleagues of mine, not big earrings, not a lot of bling. Men don't have to worry about that, but that's definitely something that I focus on, and I really try to instill when I speak with people who ask questions about how to try cases and how to dress for them.
Is there a different calculation if it's a jury or if you're just before a judge at a bench trial?
I would say no. I think it's the same way. A judge is certainly going to, size you up, especially if you're not familiar to that judge. And the way that you present to that judge is going to be a reflection of the whole package of your case. So, you don't have as many eyes on you or as many lay people, so it may not be as important. I don't think a judge is necessarily going to care as much. But in my mind, just as if I'm going to court to argue a motion on a serious case, I dress just as I would as if I'm getting up to speak to a jury.
Jan?
I guess I disagree a little bit. I think it's more important. You always have to dress well. That's a given. But in terms of eyes on you, I think that jurors really do pay even more attention. A lot of a trial is boring for a jury, and they've got nothing to do but look around, and they look at the lawyers, and they look at the client. And that you get comments if you ever do a mock trial. Jurors will always comment on clothing. I noticed, you were wearing a nice suit, or wow, this lawyer was wearing a goofy tie or a really expensive Rolex watch. They really do notice that stuff because it's something that is more familiar to them than what the rest of a trial is, which is all very foreign and strange. But sizing people up and looking at them is something that juries really do. So it really is important, and I think maybe more important for women to really pay attention to how you're presenting yourself, what messages you might be subliminally creating. And it's also important just for you as a trial lawyer to feel good about how you look. I have a tradition before every trial. I do 3 things. I get a haircut, I get one nice new item of clothing that just makes me feel good, and I read the rules of evidence. I just read them from beginning to end. That's my 3-part routine before any trial.
I also loved, I think I've heard you say that you always wear a certain kind of thing for sentencing if you do happen to have a client who's being sentenced.
Sincere gray. That's my uniform for sentencing. Not too dark, not too light, just sincere gray.
Well, it's interesting because I know, Andrew, and I've seen you on TV and whatnot. You get a little more colorful, and I think that makes sense for you. And I also can understand what Jan is saying. But here's a tiny little audience question. This maybe it's a yes or no. It's a male asks, dressing for trial: vest or no vest?
My answer is, if you're even thinking about that, then go for it. Go for the vest. Go for the style. Everyone has to have their own style. The way that I dress, I like to wear a pocket handkerchief, and I don't square it off. I puff it out. I like colorful ties, but very sort of, I don't have a lot of stripes or much on my suits. They're usually one shade of blue or another. And so that's my style. But if your style is the 3-piece suit with the vest, and that's how you dress. If your style is the bow tie. I've got a good friend of mine, and that's his thing, is bow ties, and he looks very dapper in them. You have to go with what your style is. So if you're thinking about a vest and you have it, and you think you look sharp in it, then go for it, definitely.
I want to switch gears just a touch here because we're kind of speaking of making impressions effectively. And we had an audience question where on voir dire, he was saying, he says some judges no longer allow, as we know, voir dire and will quickly seat a jury. So when this happens, what are the best ways to handle what he says he would call a cold jury, in which you've had little or no input in their selection in terms of, making your initial impression? Either one of you have a thought on that?
I do. I actually try my cases in federal court. I don't really do work in state court. And in federal court, you get very little voir dire, and in some federal trials, you get virtually nothing. I had a trial a couple years ago where the entire jury selection process took about an hour and a half to 2 hours. We knew very, very little about these jurors. And we Googled them afterwards and checked whatever we could find on the Internet, and there was one juror in particular who we were extremely worried about. He'd posted blogs and videos expressing opinions that seemed very bad for what we were trying to put on as our defense, and we really worried. Should we bring this up to the judge? Should we try to get him disqualified? What should we do? And ultimately we decided that, the old expression, if you're going to shoot the king, you better kill him, and we weren't sure that we could definitely get this juror off, so we left him on. We didn't say anything to the judge. And as it turned out, he ended up being the foreman, and he ended up being our strongest advocate. So a lesson there is, you never know when you're reading the tea leaves. Even when a juror seems like they might be awful, they might be good. Even when you think they might be good, they might be awful. Try to get as much as you can in voir dire. Try to do as much research as you can on the Internet, but take it all with a grain of salt.
I agree. If I could just touch base on that as well, is that, I'm in state practice, and the majority of the time I am picking juries, and I work very hard to try and get rid of the real bad ones and try and keep the okay ones, because that's the best you can do. But time after time after time, when I put who I thought was a great juror on my case, someone that just lined up perfectly with my client or what I thought would be someone that would go our way, time after time again, when I've spoken with jurors afterwards, I find out that someone I thought was great wasn't going our way, and someone I didn't think was great ended up being the best one for us. So it gets so frustrating because you spend so much time thinking you picked a good jury or tried to do a great job, and sometimes it's all for naught. That frankly, if you don't have as much time picking the jury and the judge does those initial questions to really screen them and they're on there, it may not be that much of a difference either way. Unfortunately, it's very tough to get to the bottom of what's going on in a juror's mind before you get them on your trial.
Well, let's talk about the things that you have then kind of prepared for when you get into opening and direct and cross and closing. One of the questions was, should you make exaggerated gestures or not? Another one says, how do you deal with the inherent distrust of trial lawyers by jurors. Regarding demeanor, do you recommend you let your personality shine through or present yourself in a very serious and somber manner, regardless of the type of case? I was going to go through, the different parts of a trial, but we need to kind of fast forward on this. So think about any of those pieces of the trial and any of if you each have a thought on how you comport and kind of build trust.
Yeah, I mean, there's a lot in there, Kathy, and as far as, whether you're demonstrative and move your arms around and all that, you have to do what works best for you and your style. Some people can't even talk without using their hands, and it would be horrible to try and tell them, don't use your hands. Some people don't like to move their hands around when they talk, and if you tell them to be more expressive, it could look awkward if they try and do it. So I always encourage people to be yourself. Of course, if you're at a time in a trial where it would be more appropriate because of the subject matter to bring your tone down or be more subdued, in that case, of course, you have to go with what's right. But in general, just be yourself, and that will come through to the jury. If you try and be someone who you're not, then you're not going to be able to really carry out your duties properly on a trial. So you really need to identify who you really are, feel comfortable with your own style, and handle yourself that way. Don't try and deliver a certain type of style just because you think that may be what should be the way to do it. You got to do what's comfortable within yourself.
And we're going to dive down a little bit more on that too in a minute. But Jan, quick thought on sort of how you comport, how you kind of build a relationship at any particular phase of the trial?
I mean, again, I agree with Andrew. Authenticity is just so important. Jurors can smell a fake a mile away. You have to live in your skin, be yourself, and comport yourself that way. The question raises an interesting point, though, which is sort of the physical nature of a trial. I mean, you do need to use your body. You need to walk around. There are times when you want to be standing right next to the witness, either to help them and guide them using a flip chart or something, or to kind of yell at them if you need a really tough cross-examination. Other times you want to be away. You want to be at the podium. You want to be almost invisible. So you need to think about your body in the courtroom and how you want to use it.
That's
and to just, Kathy, to follow up on that question about trust, if I may, how you sort of gain the trust from a jury, I think everything that Jen and I have been talking about and Will is how you do it. It's, if a juror sees that you've come to this courtroom prepared, respectful, handling things the right way, they're going to say, all right, this lawyer's the real deal. This lawyer's doing the right thing. If you're straightforward about the weaknesses in your case and not try and hide them because there's a chance they're going to come out anyway, if you let the jurors know at the outset in opening or in jury selection the weaknesses and why you can overcome them, as opposed to trying to gloss over it and then those weaknesses coming out and them finding out, those are other ways to develop trust with the jury.
Right, and I think you have an article that we posted on our webpage, or will be posting on our webpage, on opening statements, and that's www.ambar.org/advice. I'll refer back to that later in the program. But Jan, you had a fun article too, an interesting one on women trial lawyers and why women are well suited to be trial lawyers. And I think there's more content in both of those articles, and there's lots of other things you can read. And the ABA has lots of resources through its litigation section and its specialized sections like tips for if you do tort and insurance practice work. There's a lot of things you can do and read, but right now let me go ahead, if you all don't mind, to some of our real quick tips in addition to what we've been talking about. I think they're interesting, and Jan, can you kick it off, and then we'll take a tip from Andrew, a couple tips from Andrew, and get back to you at the fourth?
Okay. A tip on what in particular?
Yeah, you have your tip on conquer the stress of trial work with extreme preparation in terms of trials being stressful.
Oh, sure. Well, we have been talking about how a trial is stressful. I said it's like a roller coaster, and preparation is absolutely a key to helping that stress, because flying by the seat of your pants is a lot more stressful than the regular stress of a trial if you have preparation. The other point about stress is trials take a physical toll. It's a lot of work, and you really need to pay attention to eating, sleeping, exercising, finding a schedule that works for you, whether it's my personal schedule is to get up early in the morning, work before trial, but then knock it off at about 8 o'clock at night. Other people may have the opposite schedule. So you need to think about the physical things you need to do to combat stress, as well as the mental things like preparation.
And Andrew, interestingly, your first tip is about surprises at trial, and we have an audience question that kind of gets into that as well and asks, how do you react, if at all, if something doesn't go your way at trial? But give us your quick thoughts about turning surprises at trial to your advantage, actually.
Well, the best way to turn the surprises to your advantage are sort of what I spoke of earlier, when you're being prepared with knowing everything that you can know as far as what a witness has already said or what they've done, so that if something comes out of left field as a surprise, you can stick this right in their face and impeach them with that. Short of that, if something happens and comes up that you simply have not prepared for, there usually aren't these Perry Mason moments because there is discovery. So you're supposed to know everything that's going to come into evidence, anything that's going to be offered, anything that comes through the trial. You should have notice and disclosure of that. But sometimes, hey, the person, your adversary's prepping the night before, and they come across something great, and they haven't disclosed it, and they're going to give it a shot and try and get it in. The best thing to do in that instance, if it's something totally you don't know what to do and it's out of nowhere, is to stay calm. Look like it's not a big deal. Strut up and say, may I have a moment to the judge. A judge will always give you a moment, and you can take a break. You can take a moment in conference with your colleagues if you have them there. If not, you can step outside of the courtroom and make a call to whoever you need to. But as long as in front of the jury you're looking cool and confident, and then you take a moment to gather and regroup and get a strategy together, then you'll figure out what to do and be able to proceed properly. In that event, it's a lot about appearances.
Mm-hmm.
Can I just tell a quick story on that? The other thing is when your facial expressions mean a lot. I tried a case a few years ago where we would have bench conferences over objections, and every time my opposing counsel lost something, he would walk back to counsel table smiling as though he'd won. And every time, it was really interesting. I mean, you can play act a little bit to try to diminish if you've just been clobbered over the head with something.
A little more serious question in terms of what you do at trial and not having exactly to do with you. One of the callers asked about what's the best use of computers in the courtroom, and I know, Andrew, your next tip is to harness technology in your trial prep and in the courtroom. Can you just say a few words about that?
Sure. Well, as far as prep, the advantages of technology are, using Google, using the Internet, getting things quickly as far as research through databases, organizations, and having access to things much more quickly can help you prepare much better. As far as in the courtroom, I'm still what we might refer to as old school in that I like to have important documents enlarged and blown up by my court exhibit person on foam core and get the easel out, as opposed to doing a lot of PowerPoint presentations. But there are times when technology in the courtroom can really help. The key is getting your point across. And if you feel that, in my cases of personal injury where I have horrific accidents and there's questions whether the guide rail was acting properly on the highway, if I can bring in an expert and put up on a big screen a computer reconstruction of that so that the jury can see what we're talking about. If I can use video conferencing in a courtroom for a witness that's out of state, because we can line that up and make everything go much more smoothly than adjourning or not being able to get that witness in, or just having a deposition transcript and not being able to see the witness live. I like to use that as well. So you have to pick and choose where you think the technology can be most effective to get your point across. You have to remember that is always the goal in making your case, is getting your point across as effectively and clearly as possible.
And I think, Jan, just to finish up this tip section, I thought you had a fun one about avoiding watching fictionalized TV trials. Why?
Well, I mean, trials on TV shows bear basically zero resemblance to what happens in the actual courtroom. I mean, they get away with stuff that we real lawyers never could. So, I mean, it's entertaining, I suppose, but don't ever use fictional TV or movie trials as an example of how you should comport yourself. I mean, if you are a trial junkie and want to watch or learn more about trials, go down to the courthouse and find a really good trial lawyer and watch them in action, or go get a transcript of a really great cross-examination, or read the transcript of a famous trial. When I was in law school, in the stacks of the library, they had bound copies of transcripts of some great trials. I read the whole Chicago 7 trials when I was in law school. So actually reading transcripts of real trials or watching real trials is much more instructive than what they do on TV.
Well,
I just want to add, there is one trial lawyer movie that I love, and it's My Cousin Vinny. And it's such a great end. And if you look at it, there's actually some stuff in there that you can use, and some of the skills that are used in that courtroom are not too far from the truth, but they're just done with a lot of flair and a lot of fun. So especially being close to Brooklyn and trying cases in Brooklyn as well as other parts of New York City, we do have our My Cousin Vinny moments, and that is a lot of fun when that happens.
Mm-hmm. And I suppose, like everything else, you can look on YouTube and, maybe there are some snippets of trials. It's just hard, for you to tell what you're watching and what's, really instructive, what isn't. So we just say be careful with that. But I want to ask a question because somebody wrote in and talked about not having a great memory for details and being a little intimidated and by adversaries who have a great memory and all that. But my question really is, and it kind of relates to that, this concept of all eyes being on you at trial. People always say that most lawyers are introverts. And so I'm wondering, whether it's a poor memory or whether it's needing notes or whatever it might be, I'm wondering if you think an introvert can be a good trial lawyer. Jan, what do you think about that?
I think that you can be a quiet person and be a good trial lawyer. I don't think you need to be loud or brassy or flashy to be a good trial lawyer, but you do need to demonstrate authority and leadership. That can be done in a quiet way. It doesn't have to be loud, but you do have to demonstrate that kind of authority in the courtroom. And if you're the kind of person who just cringes every time someone's looking at you, especially when the stakes are high, then maybe you're not cut out for this line of work. You do have to be comfortable kind of being in charge of other people in the courtroom.
Andrew, what do you think about that?
Yeah, I agree. I think, it is hard if you're an introvert. You can't be an introvert in the courtroom for sure. So if you can turn that off and bring your true trial lawyer out during the courtroom, then that's important. But you have to be comfortable speaking in front of people with eyes on you. You have to be able to make eye contact. You have to look at a box of jurors, of all these people with all eyes on you, and feel comfortable speaking to them and making eye contact. And when I go to pick juries in New York City, I'm stuck in a room, me, one other lawyer, sometimes 30 to 40 people that don't want to be in that room, that I have to question everybody to think about whether I'm going to get them on the panel. And you have to be able to do that. If you're going to walk into a room full of people looking at you that are unhappy to be there, and you have to convince those people to find your way, you have to be comfortable with that and not be worried and be a deer in the headlights when that happens.
Mm-hmm. Though one of the callers asks, and I think we've sort of said it's okay, if you do, and particularly when you think it's important, as the story Jan told us, write out your questions or even use bullet points, but not to read. Be prepared, but don't look like you're reading off a script, because that's never very persuasive anyway. So basically, not everybody enjoys the battle, I guess, but you have to at least be able to tolerate it to be a trial lawyer. And so let me ask you this. We'll move. This kind of moves us to the agree-disagree moment, and I want to start with Jan, because earlier in my career, I heard someone say, trial lawyers are born, not made. Do you agree, disagree? Why?
I guess I can agree and disagree, because I think you can learn the skills of a trial lawyer. I mean, there are certain skills that I think can be learned, but fundamentally that kind of fire in the belly, the spirit, the drive, the lust to engage in combat and trial, I think that does have to be inside you. That's something that either you have or you don't. But on the skills side, there are skills that can be learned, including presentation skills. There's a young lawyer who worked in our office who was very smart and really wanted to do trial work, but was very shy. And this lawyer ended up taking not a trial practice course, but an acting improv course. And it totally just unlocked something in this person, and they're now just an outstanding lawyer. So there are certain aids you can go to try to unlock what's in you, but it's got to be in there.
That innate spirit, huh?
Yep.
Okay. Andrew, let me ask you on an agree-disagree question. Do you agree or disagree? You can't get the best settlements unless you can try a case.
Agree. Absolutely agree. You have to be able to prove that if your adversary is not going to provide the best settlement offer, and that you have to go to trial, that you're going to bring the goods, and you have the potential to get exactly what you're claiming you're entitled to, if not better. Unless you can back up your talk, so to speak, you're not going to get a good settlement. And at least in my line of work of personal injury law, any defense firm or insurance company is checking us out and is going to check out anybody, and when they're considering what kind of offer to make. And there's going to be a big difference if they check you out and you have a track record of trying cases, of getting good results, or if they check you out and they can't even find that you've been in a courtroom before. They're just not going to make the same offer. So we always like to settle our cases and not have to try them, and we have about a 95% success rate at that. And the reason for that is because of our track record for the cases that we do try, so that our reputation here is that if we don't get the right number or get a settlement in the appropriate range, that they can expect and anticipate a very difficult trial, and difficult meaning that we'll be extremely well prepared and be able to get the best possible results. So it's so important that you can try a case for the purpose of getting a good settlement.
Do the same people in your practices settle cases versus trying the cases? Or, I know if you're a solo practitioner, resources are limited, you have to be that go-to person and everything. But what about, do you guys have any approach to that if there are other people to sort of play off against in terms of trials and settlements?
Sure, it's generally whoever's in your firm. So if your firm is handling the case, they don't know. You don't necessarily have to be the person trying it if you're negotiating the settlement. You could say my partner's going to try the case, or someone in my firm will try it. It's if your firm has it or someone within your firm has the reputation. Many firms have their trial person and their settlement person, and they're separate people. You can either talk to the person about settlement. If not, you're going to see the trial person in court. So it is harder if you're a solo practitioner. But if you're a solo practitioner and you don't try cases, you certainly want to affiliate yourself with someone who can try your cases for you and bring that person into the loop to assist you in showing that you come with a little more force to the table.
Oh, that's interesting. Sort of affiliate with a trial warrior in a way.
Exactly.
If you're not one, or if you don't have one. That's so interesting. And I think you answered that next question. We're right on target, because somebody asks about what you do if you're young, newer to the profession, and don't have a lot of trial experience. And I think the ethics rules require anyway that when you're not able to prepare on your own, that you go and affiliate. But of course, we know there are all kinds of great trial programs. I think Andrew still, or maybe Jan too, coaches trial teams at law school, and keep yourself familiar and up to date and so forth that way. Let me take one very quick audience question talking about staying up to date, and this switches gears again back to, and I don't know if what you'll say to this, but back to the sort of technology, because this person asks, what is your current favorite litigation support software, e.g. Case Map, Summation, West Case Notebook? Do you guys have an answer to that?
I don't use one. I don't use one for my trials, so I'm not familiar with any of those. It's all about how you're trained to organize. I do trial notebooks where I write things in and insert them, and I use yellow pads. I don't use any iPads or laptops or anything in my trials.
Mm-hmm. Jan?
I'm pretty old school myself and do it the old-fashioned way with paper. That said, for presentation at trial, I use a service where they use some kind of evidence presentation software, and I frankly don't know what it is or what it's called, but I just say, Jeff, put this slide up on the screen, and it happens. So,
And that's where these less experienced trial lawyers, newer lawyers, can be really helpful because they know technology and they are more familiar, and so they have value to offer too. We always just think of the trial value being to get up on your feet and do it, but there may be other ways people can kind of become valuable too. And that leads me to a question that I have, because I know that trial work is stressful, and being a litigator and or a trial lawyer is intense. It's an intense career. So let me ask each of you quickly, sort of how do you balance having a life with such an intense career?
The way that I do it is by not, fortunately I don't have to try case after case after case. The majority of people don't do that. There are a few, but it's rare. So I'll have a few big trials a year, and if I'm fortunate enough, I can space them out and have time to regroup. So when the trial does come, you can really focus, really work, and put in as much overtime and sleepless nights and whatever you need to do to be ready for it and to try a good case. But when you're not on trial, it's equally important. Jan touched on keeping yourself fit and healthy mentally and physically. It's important. And then I try and spend time with my family. I have a 7-year-old daughter, and I'm married, and I get out of the city. I try and get into outside of New York, to the country, to the fresh air, and be active and just spend some family time to really get that proper balance. I'm a big believer in finding that important balance of work hard, play hard, and family time.
Jan?
Yeah, I agree. I mean, I've raised 3 kids they're all young adults now, and I've tried to spend as much time as I can with them, and while at the same time pursuing a really ambitious career. It's important that you find the right place to do that, the right employer that gives you the latitude to do what you need to balance family and career. As Andrew said, once you're actually in trial for those 2 or 3 weeks, it's all bets are off. You're just totally gone. It's as though you're either you are physically out of town or you might as well be out of town. And you need help. You need child care. You need an understanding spouse. I mean, you can't do this job alone. You do need help to help you with the balance that you need to do.
And sometimes I guess it's a matter of luck, but you don't want to leave it to that. You want to make these strategic kind of career choices when you can. And not everybody can or can't do it all the time, but we want you to be, taking the advice and being as mindful as you can. And so I guess, let me ask you each this, and then we'll want to get to our takeaways pretty quickly. But let me this easy question in a way, maybe challenging in another way. What do you like best and least about trying cases? Who wants to take that one first?
Well, one easy answer is what's best is winning and what's worse is losing. Any trial lawyer that doesn't say that should get into a different line of work. I mean, that may be crass, but it's certainly true. Beyond that, I mean, what I like is advocating for a client. I mean, especially with most of my work is criminal, and to be able to stand up on behalf of someone who has the weight of the government bearing down on them, who has, there's no such thing as a presumption of innocence. There's a presumption of guilt when a criminal defendant is sitting there at the counsel table, and to be able to stand up and be that person's champion and advocate for them is noble and fulfilling and wonderful, in my view.
I absolutely agree. The great thing about trying a case is feeling good about what you're doing, feeling good about your cause. I think most trial lawyers do it because they want to fight for their cause. I always have to believe in my case and bring all of me on behalf of my case and my client. So that I enjoy doing. I enjoy, of course, winning. I hate losing, and I hate the stress that it puts on me and my firm and my family, because it's very stressful. Scheduling can be very difficult and can interfere with important things going on in your life, so that's the downside. But the upside is it doesn't happen all the time, and when it does happen, you're doing really good work. You're feeling at the top of your game. It's very invigorating, and when it all works out, it's all the better.
Well, let me ask you this. Speaking of a time when it all isn't working out. Somebody asked about how do you convince a judge in place of a jury, and I think particularly the question has to do with someone else's inquiry earlier. This hostile kind of judge that Jan mentioned, she actively interrupts. He misunderstands what you're trying to state, doesn't give you the chance to clarify. I mean, how do you convince the judge and stand up and make your case and hopefully win that versus, when you have 12 people to relate to as various humans?
It's really important dealing with a judge, especially a hostile judge. Bear in mind that the jurors love the judge. The jurors look up to the judge as Moses or some very wise figure. And if the judge is beating up on a lawyer, they're going to assume the judge is right and that the lawyer has done something bad. And you've got to be very mindful of that. At the same time, if a judge is going the wrong way or doing wrong things to you, you've got to stand up to it. And then there are certain things you can do. You can say, Your Honor, may I make an offer of proof? Your Honor, may I be heard outside the presence of the jury? Your Honor, may we take a recess so that I can present my position on this? I mean, you need to not just back down, but in a respectful way let the judge and the jury know that there's something wrong here and it needs to be addressed. And I mean, ultimately, you're making a record. I mean, you need to, if the judge is still clamping you down, you just need to say, Your Honor, I need to make a record on this. May I please make a record so that you have it for appeal?
Right. And Andrew, take that from the position of being, there isn't a jury, but there's just the judge. You answered it any differently than what Jan just advised?
Well, it's a little different when there's a jury there. Exactly what Jan said. I mean, you have to keep your cool. You have to show your respect for the judge, regardless of how you're being treated. Even if you're not being treated appropriately and with respect by the court, you have to take the high road. It's your job. Now, if it's just you and the judge, depending on your comfort level, the longer I've been practicing and the more I've learned, the more comfortable I feel sometimes telling a judge when they're wrong. Young lawyers may not feel as comfortable, rightfully so. I like to say it helps to have a little gray hair. Those of you remember seeing my picture, I have no hair, so it doesn't help in that regard. But that's sometimes when I'll drag my father into court to have somebody with gray hair nearby. But, you can let a judge have it in a nice way, especially if there's not a jury around. And even if it's a jury trial and you go back into chambers, you can get a little bit tougher and a little bit stronger, again, respectfully so. But you have to remember who the ultimate audience is. So if you're in a case where it's a bench trial and the judge is going to be the decider of fact as well as law, you just don't want to upset that judge, because even if you're right and they're wrong, you've got to be careful of how you handle that situation, because if you upset the judge, and then the judge isn't going to find your way most likely. So you have to weigh all these things out and try and do the best thing to protect your client and your case.
Right. And if you're in a jurisdiction where there are, trial practice programs and whatnot, and you can always look on the web to find them. It's the kind of thing you can ask if you're there. Can we practice, with you being an obstreperous judge and me trying to get my, evidence in. So let me do this. Let's go to our final points, because I think, Jan, starting off with your first one, don't try to totally rid yourself of the fear of trying cases. I find that so interesting. Why do you say that?
Well, I mean, I think that fear is an essential part of trial work. If you don't have butterflies in your stomach when you're standing up to start a trial, I think there's something wrong. And it's a powerful motivator. The old expression, nothing so focuses the mind like the prospect of an imminent hanging. It's really true. It would be fear really, you should be scared because what you're doing is important, and it's actually kind of useful to be scared because it makes you work and pay attention. That said, you don't want fear to completely paralyze you, and you need to be able to conquer your fears before you can be effective. And if you're the kind of person who has fears about public speaking, for example, there are ways to conquer those fears outside of the courtroom by doing things like public speaking whenever you can. Get up to speak at the PTA meeting, or something that I've done a lot of is fundraising. Calling up strangers and asking for money for a cause you believe in is not unlike what you're doing as a trial lawyer. And getting some practice doing that can help you overcome some of those fears, or understand what it feels like to get through that fear, to get past that fear.
Well, do you do you ever have those classic achievement nightmares even at this stage of your career? I mean, do you really feel this fear to some extent still?
Absolutely. I mean, just like the nightmares of showing up to the final exam and you've forgotten to bring a pencil. I mean, I have the dreams of showing up to opening statement and realizing I don't know what case I'm trying and I can't find my binder. Absolutely, you get those.
I have the exact same dreams.
Yeah, this does not sound like a lot of fun. I'm going to go on to the next. But something more fun. Take a chance to give a toast at a wedding. Do some impromptu speaking. There are all kinds of ways, and all of them aren't connected to going to a trial practice program. So someone asked, is there a pro bono work that you would recommend? And absolutely. I mean, those are the kind of things. You have a supervisor in a pro bono case. I mean, those are good ways, I think, to get comfortable. Anything you can think about in or out of court, we want you to do. And Andrew, I think we've talked a bit about your next and final takeaway, but say a little bit more about anticipating.
Sure. Part of the preparation aspect is anticipating. You have to look at a trial as a chess match, and you have to anticipate your adversary's move to every move you make, whether it's in the whole trial strategy or just trying to put something into evidence, or your questioning of a witness and what that witness could say in response and being prepared of how to follow that up. You really want to try and anticipate what could go wrong, so you're prepared for it. You want to anticipate all the different variables that could take place, and then you'll prepare for it, and you'll be in the best way to handle it. By one of the things you can do in anticipating and getting ready and preparing for trials, you can't do it sitting behind a desk or sitting in your office. So you want to get out there even if you don't have a case. You want to get active in trial organizations, the American Bar Association, of course. Get involved. There's always different practice groups, discussions like this, local bar associations in your city or county. They'll always have programs going on where you can go and, trial lawyers boot camps. I do a lot of coaching with locally, and it's a one-day or multi-day session where you get up and you can practice questioning a witness, or you get up and practice doing an opening or a summation or objecting. And that's a great way to start developing your comfort level and of how to learn how to be more accomplished in a courtroom.
And those are good tips. Speaking of, having fun, and you mentioned every move you make. One of the listeners just wrote in too, and this would be a horror for me, but she says you can sing in a rock and roll band if one of the things you're uncomfortable with is being in front of people. Well, that would be tough for me, but but some people would could find that fun. I agree. And karaoke, I suppose, who knows? Jan, a final tip from you.
Well, my final tip was to be a mentor, both be mentored and be a mentor. I would hope that our listeners, especially the younger lawyers, should find a mentor, someone that you can get information from, get tips from, share your fears with. It's very important. And then also being a mentor as you develop in your career. I learn as I mentor younger lawyers, and I see their styles as compared to my style, and I actually learn from that as well. So mentorship is really valuable on both ends of the experience spectrum.
I think that's so great. And what I want to say to you, I told you I'd sort of get back to this page. We have resources. We have archive programs. It's www.ambar.org/advice. And again, we're going to have a couple of articles from today's speakers. They were so great. I want to thank them both so much. I hope it was as much fun as trying a case to be on this program. But we also have next month's program coming up, a little bit different. Switching gears is about emotional intelligence for lawyers. We hear these things and we think, ugh, who needs it? But actually, we're going to talk about what it is and why it matters. And I think you'll find it very fascinating. Hopefully, you participate in a lot of our programs, and if you haven't, you will. So we've now got on this page all the subject matters going forward for the bar year, and you can actually go in and register for them now. Put them on your calendar. Don't forget about us. And as they draw nearer, we'll be announcing, obviously, speakers for each and honing in on the job descriptions. So, again, we ask you to stay on the line and fill out your evaluation. Jen and Andrew, thank you so much. I mean, this has been very enlightening, even for me, and I used to try cases for a living myself, so I loved hearing your tips and thoughts. And on behalf of the ABA and myself, we do hope you'll be with us again for the monthly Career Series program for members, all of you listeners, and Happy New Year to all. Thanks much.
Thank you.
Thank you.